Today we're talking about domestic violence cases impeding breath. Very serious topic. We're talking about strangulation where a person is choking the other person out. It's very serious for both the accused and for the alleged victim. Let's get into it, but first let me just say this is for educational purposes. If you do need advice on your specific situation, I would recommend you speak with an attorney as soon as possible. These are serious charges that you do need to take seriously. I don't prejudge clients and potential clients when they walk in the door. I've seen cases where there is a lot of evidence, there's bruising around the neck, and it was clear that something significant happened, all the way to cases where the only piece of evidence is the word of someone who has been proven to be a liar in the past. So for that reason, we do have to talk about both sides, and there are a lot of false accusations when it comes to impede breath cases. Now, impeding breath is an enhancement, which means the prosecutor has to prove all the elements of a regular family violence assault, but then they also have to prove the added element that the person impeded breath or held their hand over their nose and mouth to prevent breathing. Now, this enhancement will bump a case from a regular Class A misdemeanor all the way up to a third-degree felony with a potential punishment range of 2 to 10 years. So it's a very significant enhancement. Now, the defenses in this kind of charge are very similar to the assault family violence defenses, and I cover those in other videos. But that added element of strangulation means the prosecutor has to prove that as well, and usually that kind of evidence is going to be in the form of physical evidence. If it's based just on the statement of the complaining witness, oftentimes the prosecutor will drop that enhancement even in plea negotiations, and we just proceed as a regular misdemeanor family violence case. Now, it does give the prosecutor more leverage in plea negotiations, and the reason why is this. If you have a misdemeanor family violence case, the worst it's going to be is that misdemeanor conviction, and so if the prosecutor is not willing to drop that case, there's really nothing to lose by pushing it to trial, and that gives you some extra leverage. However, in a family violence case alleging strangulation, the prosecutor can try that case as a felony. So when they offer to drop it to a misdemeanor, it does give you an incentive to plea that case to a misdemeanor. For that reason, in a lot of jurisdictions, and this doesn't happen in Travis County as much, but in some more conservative jurisdictions, they will find ways to charge the family violence case with that enhancement with the intent of dropping it down just so they can give their prosecutors that extra leverage. But beyond that, we're still looking to push the prosecutor to show us their evidence. If it comes down to a simple he said versus she said, it can still be worthwhile to take that to trial because the prosecutor will be very hard pressed to prove it beyond a reasonable doubt. And even if they're offering to drop the case down to a misdemeanor, you still have to contend with that family violence finding. It's a serious consequence even when it comes to misdemeanor assault, and if you can avoid that, you definitely want to do that. All the other strategies like getting corroboration from the complaining witness, showing that the complaining witness has lied in the past or has been charged in the past with similar crimes, all of those strategies apply, and in a lot of ways the impede breath case proceeds very similarly to how a misdemeanor case would proceed. It's just that the stakes are higher. One thing I've noticed is that this area of law is rife with false accusations, and I believe there are a couple of reasons why that is. First of all, most of these happen behind closed doors, so there's only 2 eyewitnesses to what happened, the complaining witness and the person being accused. Secondly, the police come out and they ask the complaining witness a standardized list of questions. One of the questions they ask is, did they ever put their hands on your neck? Did they ever cover your nose and mouth and prevent you from breathing? And if the complaining witness just says yes, that's enough sometimes for the police to enhance the charge to impede breath. And for that reason, a lot of charges that don't really have the evidence to back it up are charged as impede breath cases. So impede breath cases and family violence cases are often very weak for the prosecutor, and for that reason, it's even more important that you get a good attorney on this. Statistics show the widest variation between court-appointed attorneys and hired attorneys when it comes to these specific types of cases. The hired attorney can make a real difference when they're being just a little more aggressive and they're pushing the case a little harder on the prosecutor, forcing them to prove their case beyond a reasonable doubt. For that reason, if you are facing felony DV charges like impede breath, speak to an attorney. I offer free consultations. A lot of other criminal defense attorneys offer free consultations. You can visit us at atx.legal to set that up. 30 minutes, I'll speak to you for free on the phone.